As some of you may know, if you've been around this industry for a while, to have an event like this is really quite unique. And when I founded Standard Invest in 1999, it was my goal to return to the industry, something that they had given me. And so we started with this, what we call the annual safety issues update. And it was in that section over there and did not fill the room. And to Glowstone's credit, they've not only continued it, but they've expanded it to such a degree, I think, in our area, and typically online as well. It's really quite an event that you look forward to at the beginning of the year, or at least sometime during the year. So my topic today is preparing for your day in court that you hope will never come. And since we're talking about legal matters, you'll see a disclaimer up there. I am not an attorney. I am not qualified to give legal advice. I've not been to law school. I feel like I've been to law school, the number of attorneys I've been around, but I have no diploma or certificate. But what I do want to share with you today is what I've gleaned at the 30,000-foot view of over 20 years as what's known in the industry as an expert witness. Now, that term expert, when it comes to this field, simply means that you know something about it, and at some point in time, a firm has decided to retain you, pay unreasonable amounts of money, and the courts have allowed you to come in. That's it. I've probably testified in the neighborhood of 50 to 60 cases. Now, that's not huge. In fact, I'm not even in the major leagues when it comes to that. There's a case, actually there's two cases I'm currently involved in which one of the experts who I've seen before on his website says in 20 years, he has testified 1,500 times. Now, if you do the math on that, you may start to question how does he ever do justice to the case. I don't know. That's not it. But I'm not in that league. But I have been in the trenches, so to speak, often enough to see some things that help motor carriers when they are taken to court, and some things they fail to do which did not help them. So first of all, we look and we say, well, what do I want to do today? What do I want to do today? Okay, share some insights. And I also want to remind you that being right in the case is no guarantee a jury is going to agree. Let me give you a case in point. A few years back, a shipper contacts a brokerage to ship their product. The brokerage finds a motor carrier that has 3 trucks and sends a driver to pick up the commodity, which has no experience with that commodity in the past. The load is apparently not properly secured, and part of that cargo is lost falls off on an interstate highway. Happens to be towards the evening hours. Retired couple in their RV are coming along, and out of the darkness, all of a sudden, there's this object in the road which they strike, and it pushes their RV off the road. There's some injuries to the elderly couple, nothing life-threatening, but serious injuries, and so they sue. And typically in a litigation, plaintiff's attorneys will name everybody in the lawsuit they can imagine. And they'll let the court sort out whether they actually belong in the case or not. So in this case, the motor carrier was named and the shipper was named. And I happened to have the opportunity to testify in that case, which I did. And clearly, the driver had not done something that the driver should have done. So it did go to trial. And a few days later, I learned that the jury came back and decided it was the shipper's fault and the drivers of the RV. And the motor carrier had no fault in it whatsoever. Now, in my mind, that clearly was not what the case was. But it bears out the point that even if you are in the right, it's no guarantee that the jury is going to agree. And that's always a good thing to remember. So why is this relevant today? And you'll see a few slides here. We'll kind of go through. There's been about 4,800 crashes in 2016 where there are fatalities from commercial motor vehicles. And so that raises the question, and these are dated photos, I know that. You can get many more current photos off the line online there. But it brings the point up that probably many of you in this room, if not maybe the majority, at some point had one of the vehicles or your drivers in your company involved in a DOT reportable crash. Show of hands, how many have had that experience? There's no, by the way, we're not taking pictures, okay. A relatively small number. That doesn't necessarily mean the rest of you, your company hasn't had that experience. Statistically, you probably will during the course of time that you have. And when that time comes, certain things are going to happen. And we'll talk about that a little bit today. We want to do like the 30,000-foot view. So what I'd like you to do is to kind of sit back and imagine that I'm just sitting with you over coffee. We're sitting with you over coffee or whatever. And we're talking. And you explain to me that you have a safety responsibility with a motor carrier. And I want to say to you, listen, can I share with you some of my experience, the things that I've learned? Or I can share things with you, or with all of you. Okay, can we do that? So let's talk about, first of all, just some general principles. First of all, full compliance with the FMCSRs, the Federal Motor Carrier Safety Regulations, is not the guarantee that you are going to be found not liable. In virtually every case I've been involved in, it's pretty well standard. One of the things the defense counsel looks for on your behalf, and that a plaintiff's counsel looks for to lodge their litigation, is an expert who can comment on what's called the industry standard of care. Now think about that. What in the world is the industry standard of care? In simple terms, it's what in the industry we typically do. I'll give you for an instance. If you look in the FMCSRs, Part 390, I believe it's point 3, might be paragraph E. I kind of have that embedded in my head here. There's a statement to the effect that the motor carrier must instruct their drivers, their employees, in every area that's applicable to them. It doesn't say what training you are required to give. But we go to our conferences, we go to our major motor carriers, and we find that there are certain training topics that are almost universally given. And you can probably think of a few. Defensive driving, road rage, speed, space management, load securement, hours of service, drug and alcohol. And you have a list then of what really is the industry standard of care. And so that part will always come into the litigation in a very predominant way. So if you are, I'm just curious, how many of you are safety people here, person in the company? Okay. And lower your hand unless, well, those you raise your hand. How many of you have been in that field for 3 years or less? Okay, 1, 2. How many 5 to 3 years? Okay. How many of you who raised your hand at any point went to school somewhere to learn how to be a safety professional? One person might have. Isn't that amazing? Maybe 2 people. Because you see, in this industry, you typically get that role by default. You're the person who is doing something else. You might have been in dispatch. You might have been a lead driver. Any number of things you might have been. And somewhere along the line, somebody says to you, well, do you know something about hours of service? Yeah, I just went to a workshop. Great. We would like to make you safety person here. You know how to secure a load? Yes, I think so. Good. You're the safety person. And typically I've found that unless you're in a larger motor carrier that has the funds and the means to really support a safety department, you may spend 25 to 50% of your time at the most in safety and the rest of the time doing something else. Is that true? Okay. But the results of your work is what will end up in the courtroom. I guarantee you of that. The fact that you're being here today or watching this podcast over line is one of the best moves you ever made, because you're going to know things that most people do not know. And it's what they don't know and what they don't practice that always hurts them. Foreseeability. Again, I'm not an attorney, but I've had attorneys tell me that foreseeability can be a major factor in a litigation. Foreseeability is, for example, if you have a truck that has a cargo, let's just say a load of gravel, for example, or big rocks, I'm just picking that up out of the air, you can foreseeably believe that it's possible that rocks might come off that load, right? Or if you are transporting logs, it's foreseeable that pieces of those logs, like bark or whatnot, might fall off your trailer. And you can go on down the line with that reasoning, that it's foreseeable if you put a truck on the road, certain things might happen. A tire might get flat. A piece of tread might come off. Brakes might not, you fill in the blank. So part of your job is to understand foreseeability and to act positively to it rather than reactive to it. Document your training. I have 2 cases before me right at the moment, and I can't, of course, go into those. But they're typical of many cases. In both instances, at least half of the defense for the motor carrier is the fact that they do have good documentation of the training of their driver. Because a plaintiff's attorney will go back instinctively, or their expert will, to Part 390.3, Paragraph E, or Part 392.1, which each require the motor carrier to instruct and train their employees. And if you do not have good documentation of that training, you fail on that point instantly. And believe me, plaintiffs will make hay with that. Now, typically when I work with motor carriers or talk to groups like this, we all say that we have training. But isn't it true sometimes that we don't follow through with our training as efficiently or completely consistently as we ought to? And again, I have to assure you that if you do not, that will come to light. And the other thing is, in the vast majority of the cases I've been involved in, the accident happened precisely because the driver who was driving had not been sufficiently trained in a specific area, and it resulted in a crash. So keep that in mind. Again, I'm looking at the 30,000-foot view. Equip your safety staff for the job. Now, in this room, are there some company owners? Who will admit it? Okay. Now, you see, again, that's totally typical. We have 2 company owners here. We don't have others. They've given you that responsibility. If you're with a company, and I'll get a little bit risky here, but if you're with a company who will not invest in your training and expects you to be a safety person, professional, you might consider looking for a company that would. Like I said, that's on the edge, but it's for your benefit. Is this being recorded? Oh, well, here we go. Get me a good attorney. Standard written onboarding. It used to be when I first did this 20 years ago that as long as we could look at a DQ file that was reasonably complete, we had an orientation, and of course there was a road test, and there was a drug test. We figured we'd done everything we should do. Increasingly, you want to have a standardized process for how you onboard a driver. Your major motor carriers do that. And why do they do that? They do that because from experience, they realize that when they don't, then they don't have a consistent hiring standard. They don't have a consistent standard among their drivers, and it comes back to bite them. So if you're in a company that says, well, I'm going to hire Bob because I know Bob's brother. Bob's brother and I like to go watch the football games, and he needs a job. Well, what's his experience and background? Not that good. His MVR is a little off a little bit here and there. But Bob's a real good driver, or at least his brother-in-law says he is. If you're going that way, it has the potential, again, of coming back and hurting you in the end. This is, if you take nothing else away from this today, I want you to remember this point. So let's imagine just for a second that your driver has gone out and he's driving a refrigerated van, and for some reason or other, things have gone out of control. Maybe it's slow, it's snowy, icy, whatever. He's driving too fast, who knows what. Loses control, hits a couple cars, it's horrible. It's on the evening news. And so your driver sends you a quick text. Boss, I really never meant to do it, but somehow the truck got out of control, and the next thing I knew, it's a crash. And you text back, well, you idiot, why in the world did you do that? And he texts back something for us. What I'm saying is those informal communications, even your official communications and emails, they're all possible. They will all come up in what's called discovery. You want to keep your communications following an incident very professional, very specific. Leave the editorializing out and keep them the kind of information that if they ever are brought up into court, they're not going to come and work against you. We all say things, do things, write things, et cetera, in the heat of the moment, and we think afterwards, shoot, I should have never done that. So keep your communications professional and controlled. So what I'm going to do this afternoon, talk about 4 cases. 2 of them, you'll see where the motor carrier, their practices came to their defense. 2, where the motor carrier did not follow procedures and they hindered their defense. So the first one, we have a commercial motor vehicle driver who's driving and loses consciousness. The vehicle he's driving crosses the center line. One vehicle coming from the other direction is able to avoid a collision. And the next one, in a 20-something-year-old young woman, hits the CMV head on, and there's a fatality. Horrible case, absolutely horrible case. Not the kind of thing you want to be involved in. Well, a few of the specifics of this, so you'd know, is our driver in this case had sleep apnea. Our driver in this case also had high blood pressure. And obviously, the driver in this case passed out. Now, if you think about that, you might come to the conclusion pretty quick, the motor carrier is sunk, right? Somebody else is going to own the business. Well, here's what the motor carrier did very well. First of all, yes, the driver had sleep apnea. And the driver was under regular and consistent observation by his physician that he was using his CPAP machine on a regular basis. And I believe it's like supposed to be 70% or more. I don't have a CPAP. That's required. So A, he was using the device in the appropriate way, so fatigue was not an issue. Secondly, not only did the driver go into for a DOT physical on an annual basis because he had blood pressure issues, but he saw his private physician who also was monitoring and controlling that condition. So the motor carrier had good documentation of the physical elements of the case and could show that they were not doing anything that was showing negligence. Now, here's what actually happened in that case as we went on and were able to defend it. The driver on the morning in question we're talking about had woken up not feeling too well, but took a couple antacids and went on and proceeded with the trip. Partway through the trip, still not feeling too well, so goes and again takes a few antacids. Drives a bit farther and he's feeling, I do not feel well. So he does exactly what an ill or fatigued driver should do, and that is he started looking for a way to get off the road. Unfortunately, in that case, the road was narrow, and there were little to no places where he could pull off the side of the road safely. Before he could find such a place, he lost consciousness. Well, of course, there was a doctor involved afterwards to examine the driver and try and unravel all this. And what had been discovered was, because of a flu bug that had come on, the onset of a flu bug, his blood pressure had plummeted. And because his blood pressure plummeted, and there's a medical term for that, he had a momentary lack of consciousness. Nothing the driver could do. The driver was trying to do what he should do properly. The motor carrier had done everything they should do. And all of that worked together to a good defense. Second case. Not all the cases I get involved in are as a result of crashes, I suppose, 2 vehicle crashes. Some are not. This is one that was not. So a driver is driving in a high winds area, and decides that although there have been warnings, wind warnings, he's going to drive anyways. And you've got a dry van and it's empty. Winds at some point were peaking, I understand, up to 50 or 60 miles per hour. So at some point along his trip, his tractor trailer turns over, skids a great distance, driver gets injured. Well, the driver, of course, goes and gets a workman's comp claim. And sometime subsequent to that, he's terminated. Now, when I was first contacted about this case, and the attorney was talking to me over the phone and began to explain the particulars, he named the motor carrier that was involved, and I thought that the motor carrier he named was the one who was going to be, plaintiffs were going to charge to be at fault. And I told him, I said, you know, I have experience with that motor carrier. I said, I don't think you're going to be successful in your pursuit. And he says, oh, you don't understand it. We represent that motor carrier, and we'd like to know if you would be retained. I said, no problem, because I know that motor carrier and the plaintiff doesn't have a case. Well, the driver went on to sue, claiming that the motor carrier had been retaliatory and that one thing and another. And the thing that worked for this motor carrier, and they're a Northwest motor carrier, is they had very consistent policies. Remember I mentioned earlier? They had very consistent professional documentation of all their communication with the driver. And they could demonstrate that they had terminated other drivers for exactly the same reasons. So because they had policies, acted consistently with those policies, and they were written, and they had good communications, the case was dismissed. It never went to court. Now let's talk about the ones that didn't turn out so well for the motor carrier. So, and this one was kind of tragic for the driver. We have a owner-operator, an independent contractor. And during the course of his trip, he's not feeling well. So at a certain point, he pulls over to a rest area. It's in Oregon, to get some rest. And a fever develops. In fact, he got quite a fever. And as it turns out, his big toe has an abscess, and it's gone into blood poisoning and infection. So he calls dispatch, and he tells dispatch that he can't continue with the trip. Dispatch says, fine, we'll go ahead and send another driver up there and pick up the trailer. So far, everything is happening the way it should happen. Well, after a while, the driver has gotten to a point where he can't even get out of the cab of his truck. And he's having to relieve himself in containers within the truck. I mean, this is really, really getting sad. One of his fellow owner-operators, who happens to know that this has gone on, decides to stop at the rest area to get Joe something to eat. He stops, he sees Joe, and Joe is really, really sick. So he goes, gets Joe something to eat. He comes back, and driver number 2 calls dispatch and says, hey, you got to do something. Joe here is really, really sick, and he describes the situation. Dispatch calls Joe, who at this point is, he's, I forget what the word is, when you're in such a fever, you don't even, not hallucinating, but anyways, you get the idea. He doesn't understand what he's saying or the questions. Dispatcher says, hey, Joe, do you want us to get you some emergency help? Joe, no. No, he says no. Well, Joe says no because he wasn't sure about his insurance. And he also says no, a medical professional will testify later, because he was not coherent, completely did not understand. So at this point, the driver who had brought him food finds a good Samaritan driver who happens to be going down the I-5 corridor, who agrees to stop and drive Joe's truck to Portland so that he can get medical help. Drives Joe to his home in Portland, and Joe's wife, when she opens the door of his cab of his truck, her description in court was it looked like a slaughterhouse. Are you getting the picture? So she takes him to the emergency ward, and they have to amputate his foot. It's gone so far to save his life. A week later, they have to amputate his leg below the knee to save his life. And as you might imagine, there's a lawsuit that goes on. Well, there may not have been anything technical or legal about what the motor carrier had done. What really worked against them was what did I say? Okay. Their company failed to show that they took reasonable steps in that case. And one of the most simplest reasonable steps there was, and I testified to this on behalf of the driver, is you have two competing statements about the condition of the driver. One from the dispatcher who says, hey, he said he was okay. And two from the other drivers who said he's very, very sick. So what would a reasonable person do in an instance where you have such conflicting information? Well, call the state patrol and say, would you please stop in and check on our driver at the rest area, mile marker such and such, which they did not do. When this went to the jury, and how this happened, I have no idea in the world, but somehow on the jury, a retired police officer and a truck driver were on the jury. And the plaintiffs only asked for $2.25 million for the loss of a leg. And the jury came back and said, we would have given you 3 times that amount. It wasn't so much based on the specifics of rules and regulations, but there we get into what you might call the reasonableness or industry standard of care or foreseeability. Okay, fourth case. Company buys a used truck. And this used truck they buy, they have to get their mechanic to come down to get it started. Now, I need to stop right here. Is that person in this room? Am I describing? I hope, and you wouldn't say it if it does, would you? You would tell me to shut up, wouldn't you? Okay, just don't keep nodding because you're starting to worry me over there. I'm not naming anybody, but I'll give you the particulars. So they have to get their mechanic to come and start the truck because it won't leave the lot. And in the course of delivering the truck, as I recall, or I should say the first time they use the truck, they have drop axle, use the drop axle, and they have recap tires on the drop axle, and one of the tires loses its tread. The tread goes through a windshield and causes serious harm. Now, whose fault is that? Now that becomes a case where it's really hard to tell because we really don't know if it was catastrophic failure, because that'll happen sometimes on even a brand new tire. No one really knows. But what we did know was that following that one tire decapping, the motor carrier did not have the second tire, which of the same age or vintage, replaced. And when the information was brought out on vehicle maintenance, there was what looked like a clear pattern of the motor carrier kind of going on the cheat. Now, so far, we're not in too deep a water at that point. But when the owner came to testify, and the owner testified that he checked tires every day, he said, when the trucks left the yard. And when he was cross-examined on that a little bit more, his credibility and his demeanor and everything changed. And you realize that, no, he did not check the tires every single day. And the evidence suggested, I'm using the term suggested, that the motor carrier was not serious about safety. That case was dismissed from court purely on the credibility of the owner and the records that they had to submit. So, well, that was loud, wasn't it? Let's get a couple final words before we go on. And as I said, we're at the 30,000-foot view. I talked to Dave Gray, and we've considered offering a half-day workshop on this subject and also what we call applied legal defense strategies. So if that's something you're interested in, please contact Dave, and we'll see how that might come about. So, couple final words. The role of your insurance company, and we have an insurance company right out there. Do we have insurance representatives in the room today at listening to me? They'll probably hear me later. Okay, I'm glad they're not. Well, no. Your insurance company is both your best friend and also possibly someone you may want to help out sometime. Because what's their business? Going broke? Anybody found an insurance company so far that says, gee, we just want to go broke? Do you see your insurance rates going up? They go up because a couple things, and one of those factors is they have to cover what they paid out. And they have actuarials and other things. So typically what will happen on the defense side, this is not the plaintiff's side, this is the defense side. Let's talk about the plaintiff's lawyers first. Plaintiff's lawyers, as a custom, do not get paid unless they win something. And so they're highly motivated. They get experts involved early in the game, usually, because they want to win the case. What they really want to do is to convince the insurance company that it's better to settle than to go to court, which most of the time they do settle. Now, the insurance company on the other side, they've kind of got a ledger, if you like, and they're looking at what it's costing them to defend the case, what it might cost them if it ever goes to court, and what they can settle for. And sometimes what they're willing to settle for or risk taking your case to jury trial is not entirely the way you would have it handled. So my point is that you do have the ability and the right to employ your own attorney to supplement it. And that happens. That's not uncommon. I've got a case like that right at this moment. And what that will do is that will ensure your best interest, because you're paying that attorney, that your best interest will be represented. In choosing attorneys, unless your brother-in-law's best friend who is an attorney is a really specialized attorney in transportation, don't use them. I had a acquaintance whose daughter was killed by a truck driver who was on meth at the time. And I made some recommendations for attorneys that he might consider to represent his family and the loss of his wife in that case. Very qualified people. And he had a friend in Arizona who was an attorney, and he had been an attorney for an insurance company, as it turned out. And as I worked with that attorney, what I found was every reasonable thing that I raised as an expert that the motor carrier should have done, the former insurance attorney could only think of defense against it. And it really was not handled, in my estimation, in the way that was in the best interest of the family. So there are attorneys who specialize in this. And if you don't know them, talk to the folks at Flowstone, Dave Gray, talk to the people at OTA. They're very, very competent in what they do. And you will be glad if that happens. So thank you for your time and attention. That's my assistant there. Okay, not going to jump off the cliff. If you have any questions, I'll be glad to do my best to answer them.